and it won't help the people of New Zealand.
Sorry to interrupt the member. I call David Clendon.
Thank you, Mr Speaker. I think the best thing one can say about this bill is that the title recognises that we are in dire need of amending our corrections system. At every level, at the legislative level, at the policy level, at the level of practice, we need some fundamental change. We need a comprehensive review and oversight of the legislative and the policy and the practice in our prisons. We need effectively a culture change, both in terms of how we develop policy and legislation and how we implement that in our prisons. Sadly, this bill doesn't go beyond the title in terms of effecting that real and very necessary and much needed change. This bill makes some minor tweaks, it meddles around the edges, it achieves one or two beneficial outcomes, but for the most part the outcome of the changes in this legislation will be negative. They will not serve the ends that it sets out to serve. They will be negative outcomes rather than positive ones. I just reference the chair of the Select Committee who mentioned once again benefits that would flow from this bill. And I would say again, the question must be raised, benefits to whom? And we've seen clearly the private sector will potentially benefit very much from from the embedding of further provisions that enables and facilitates the entry of private sector operators into the correction system. As we heard from Mr Goff, Serco potentially will benefit to the tune of 30 million New Zealand taxpayers' dollars each and every year after the opening of the White Elephant at Wiri. So often one hears that the correction system is in a state of crisis. Commentators often refer to the crisis in our prisons. I actually think that's the wrong language. Crisis suggests something sudden, something unexpected, something acute. And actually what we have in our prisons is a chronic situation, a chronic condition of failure. And that failure has been accelerating over at least the last 20 years. That chronic condition of failure is represented financially, for example, in the fact that we've seen something like a 250% increase in the amount of taxpayer money going into prisons over the last decade or so. In the early 2000s, we had a corrections budget of some $460 million a year. Last year, it went close to $1.4 billion. That increased expenditure might be acceptable if we were seeing better social outcomes, but equally we are failing there. We are not breaking the cycle of offending and reoffending. We are putting, up until a year or so ago, the prison population was increasing dramatically. Failing a chronic condition of failure, this bill does very little to deal with the key drivers of that failure, with the reality of it. The decline, the advancement of this failure, if you like, the decline in the well-being of our prisons, the decline in the economic value of our prisons has increased considerably, in part to what I've been thinking of more and more of an arms race that we saw over a decade or so, driven by, I think, this false perception of what's been called penal populism. The flawed idea that the public was demanding more and more serious and longer sentences, the false perception that was created by organisations like the Sensible Sentencing Trust, who are sensible in name only. The media were complicit in building this public perception that crime was on the increase in New Zealand, that it was becoming more dangerous to be a New Zealander, that public safety was being degraded. None of that, in fact, was true. None of the evidence supports that penal populism that drove policy in a very unfortunate direction for at least a decade. I'd like to refer to a speech made just a few nights ago by Kim Workman, the director of the Rethinking Crime and Punishment Project, director of the Robson Hannon Trust, and a well-respected person with extraordinary depth and breadth of experience in corrections. His speech, he said, he set out by he would consider the idea that the well-being of a nation is measured not by the absence of disorder, but by the presence of justice. And it's very hard to see that we have improved or enhanced the delivery of justice in New Zealand over the last decade or more. When one considers, as one indicator, the number of people we lock away in our prisons every year, In the late 1980s, things began to go very wrong. In 1987, we locked up about 91 out of every 100,000 New Zealanders. By 2009, that number had increased to 200 per 100,000 of population. 200 out of every 100,000 New Zealanders by 2009 were being put in prison. It's dropped marginally now. We're down to about 194 per 100,000 of population. We desperately need to address the root causes, to ask ourselves why is our prison population exploding to this extent? And this Corrections Amendment Bill sadly does little or nothing to address those core questions, to provide any significant answers. To put that number 190 to 200,000 per 100,000 in context, we look at Germany, where the number is 83, France 102, Australia 130. We've long since caught up with Australia in terms of imprisoning people. We've well exceeded their numbers, and not an achievement I think we should or could be proud of. With the numbers around 190 to 200, we are in company with countries like Moldova, Slovakia, Gabon and Namibia. And this is probably not company that we would aspire to be in terms of locking people away in our society, rather than dealing with the root causes of crime, offending and finding better ways of breaking that cycle of offending. So it gets worse. We imprison something like 700 Māori per 100,000 of population, something like 6 times higher than the non-Māori rate. That is unacceptable that an ethnic minority, our treaty partner, is being imprisoned at a rate something like 6 times that of the non-Māori population. Māori are remanded in custody at something like 11 times higher than the non-Māori rate of remand in custody. We have to drill a little bit deeper than fiddling around the margins and talking about efficiency and effectiveness in delivering our prison services. Rather than, we need to drill a lot deeper than that and address some of the root causes of these inequities. The point is routinely made that in fact, it ought to be routinely made. It's not well enough understood that the relationship between crime and imprisonment rate, nowhere in the world is there a linear or a cause and effect, a solid relationship between imprisonment rate and the crime rate. The imprisonment rate is not a measure of crime rate. It is a measure of a consequence of legislation, of policy and practice in our prisons and elsewhere. The longer people stay in prison, the more likely they are to offend, not less. The very late presentation of the endeavour to undo the mischief, what's been called the monumental stuff-up of the smoking ban, has been addressed. The point was made by a government speaker that the opposition seemed to oppose the process by which that ban was opposed. I'd have to say we're in very good company. We're alongside the High Court, Justice Gilbert, who called the ban unlawful, invalid and of no effect. And yes, a long-term inmate at Paremaremo has successfully taken the government to court and won. And that case is again to come to Pure Court in a matter of a few days. And the court will be confronted with legislation which raises 2 fundamental constitutional issues, which this SOP does. The question of the imposition of retrospective criminal liability, which it effectively does impose, and the removal of the right of access to court for a wrong that has been done by retrospectively changing the law. It is unacceptable, whatever one's views about the benefits or otherwise of reducing or eliminating smoking from prisons, it is unacceptable for this House to accept that that process, that illegal process, should be allowed to stand, should be put right by a retrospective change put in the last minute to a piece of legislation, a bill that was never intended to address such a situation. Sir, I'd like to, again, in his speech, Mr Noam Chomsky has said the more privilege you have, the more opportunity you have. The more opportunity you have, the more responsibility we have. We have in this House an absolute responsibility to make the corrections regime better. This bill does not achieve that. We will be opposing this. Thank you.
I call Mark Mitchell.
Thank you, Mr Speaker, and it's a pleasure to take a call on this.